Welcome to Criminal Law. Before we get into a lot of detail about criminal law, I want to discuss the differences between criminal law and civil law. Civil law relates to the duties between persons or between citizens and their government, except for the duty not to commit a crime. Criminal law, on the other hand, concerns wrongs against society declared in statutes and punishable through fines, imprisonment, or death. Crime. Now we have to talk about how crimes are classified. Crimes are classified based on how serious they are. The most serious crimes are felonies. Felonies are punishable by death or by imprisonment in a state or federal penitentiary for more than 1 year. Felonies can be subdivided by the type of punishment. Capital offenses, crimes punishable by death, are the most serious types of felonies, followed by first degree felonies, punishable by life imprisonment, and so on. Misdemeanors are less serious crimes, punishable by fine or by confinement for up to 1 year in a local jail. An example of a misdemeanor would be disorderly conduct or trespass. Some states classify misdemeanors according to the lengths of confinement. Moving down the line are petty offenses. Petty offenses are a subset of misdemeanors. A party guilty of a petty offense may be put in jail for a few days or fined or both. Traffic violations are an example of petty offenses. Now, our least serious crimes are infractions. Infractions are generally punishable by fine or community service. Failing to clean up after your dog is an example of an infraction. We've talked about how crimes are classified. Now we have to talk about how criminal liability is established. Criminal liability requires two things. First, the performance of a prohibited act called the actus reus. And second, a specified state of mind called the mens rea. All criminal statutes prohibit certain types of behaviors, and both the actus reus and the mens rea will be given in the applicable criminal statute. Let's talk a moment about the actus reus. What exactly constitutes a criminal act? The majority of crimes require an act of commission. That means doing something that's against the law. An example of an act of commission would be robbing a bank or stealing money on the low. Some acts of omission are also crimes, such as failing to pay taxes. I'm sure that everybody knows that if you work, you are required to pay taxes to both the federal, state, and local governments. If you don't pay your taxes, you've committed a crime, failing to do something that the law required you to do. Attempting certain acts may also be crimes if substantial steps toward a criminal objective have been taken. If you look at the example, we'll see a person who attempted to rob a bank. Clearly, substantial steps towards a criminal objective were taken. We see him with a mask. We see him with a bag that he thought was full of money, only to be full of dollar sign symbols. Even though he did not achieve his goal, robbing the bank, because he tried to rob a bank and took substantial steps towards achieving that objective, he would be guilty of attempted robbery. Now, the key here is what constitutes substantial steps. Well, a substantial step is more than merely planning. Once again, a substantial step is more than merely planning. Because if you plan to do something, that means you're thinking about it. You might have the requisite mental state of mind, but that's all you've done. You just thought about it, and thinking about something is nothing, right? You would have to take it a step further. Maybe assembling a crew to rob the bank, maybe buying plans to rob the bank, maybe surveilling the bank to figure out the best way to rob the bank. You have to take substantial steps, which is always more than just thinking about it. What constitutes criminal intent is a little more nuanced. What constitutes a wrongful state of mind varies according to the act. Now, to make it a little simpler, there are three types of crimes based on intent. The first are general intent crimes. General intent crimes are crimes where the perpetrator intends to commit a specific crime with no specific target. A crime like assault, a crime like arson would be general intent crimes. If any of you have ever been in a club or a bar and seen a fight start between two drunks, one of the things you might notice is one drunk intends to punch another drunk. The drunk throws a punch, misses his intended target, and hits somebody else. Now, in the eyes of the law, that's a general intent crime. Why? Because he intended to throw the punch. Who got hit is irrelevant, just the intent to commit the crime. Arson. You decide to burn your house down because you don't want it anymore. You set your house on fire, you're looking at the fire go up, an ember floats from your house onto your neighbor's house. Did you intend to burn your neighbor's house down? No. Did you intend to start a fire? Yes. So you're liable for burning your neighbor's house down. Why? It's a general intent crime. Question: did you intend to commit the crime? Yes. Did you have a target in mind? No. The second type of intent is specific intent. Specific intent crimes are crimes where the perpetrator intends to commit a specific crime against a specific target. The perpetrator intends to commit a specific crime against a specific target. An example of a specific intent crime would be robbery. When a robber robs the victim that they robbed was the victim that they chose. So here we go. The victim that they robbed was the victim that they chose. We have a specific crime, robbery, and a specific victim, the robbed person. Doesn't matter how long it took them to plan the robbery. All that matters is they intended to commit a specific crime against a specific target. Number three are strict liability crimes. With strict liability crimes, the actus reus proves the mens rea. The guilty act proves intent. Strict liability crimes include sale of alcohol or tobacco to an underage person. It does not matter how old you thought the person was. All that matters is that you sold the alcohol or tobacco to the underage person. With strict liability crimes, the perpetrator's intent is irrelevant. All that matters is what they actually did. Establishing that a person committed the guilty act and had a guilty mind is absolutely meaningless unless it happens at the same time. We call this concurrence. The guilty act and the guilty mind, the requisite intent, must occur at the same time. If the two don't occur at the same time, the perpetrator might be liable for committing some other crime, or they might not be liable for committing a crime at all. Think about this. Have any of you ever thought about doing anything illegal? Now, I know you're going to say no right away, but if you think about it, you have, whether it's you're on the train, somebody steps on your shoe, you decide you want to take them out because they did that. That's mens rea, right? That's a criminal intent. But here's the thing. Did you do it? Probably not, or you wouldn't be sitting in class today. So you had the intent. Without the act, you know what you have? Nothing. There is no crime. Conversely, I bet some of you have been to house parties, maybe in the wintertime, and because certain things are in style, like coats, everybody has the same black coat. And when it's a house party and you got lots and lots of people, you don't have closet space. Where do you usually put your coats? On the bed. You've been at the party for a couple of hours. You've had a little bit to drink. You're feeling good. You're tired. It's time to go. So you go into the room and you get your coat. When you get to the train, you realize that the coat that you got wasn't the coat that you brought. You picked up somebody else's coat. You have the actus reus for stealing. You stole somebody else's coat. But here's the thing. Did you intend to steal the coat? The answer is no. You thought it was your coat. So you know what we have here? A mistake, not a crime. A mistake, not a crime. Once again, the guilty act, the actus reus, and the guilty mind, the mens rea, must happen at the same time. You decide that you want to rob a bank. So what do? You get a crew together, you get plans for the bank, you get your weapons together so you can put guns on people, and then you roll into the bank and you rob the bank. You know what we have here? We have concurrence. You intended to rob the bank, specific intent crime, and you went in the bank, you pulled out your guns, you pointed them at the teller, and you said, put the money in the bag. You have the guilty act. You combine the two, once again, it's concurrence. What do we have? Criminal liability. Since this is criminal law, I would be remiss if I didn't speak about corporate criminal liability. A corporation may be held liable for crimes committed by its agents or employees within the course and scope of their employment. Now, what do course and scope mean? That means while they're doing their job, right? It's not something outside of what they would do normally to achieve their employer's goals, right? Frequently, repo companies run into problems because they'll have a repo person go to repossess somebody's car, which is what they do for their job, but there are certain things that they are not allowed to do. For example, if the owner to the car comes and jumps into the car, right, they can't engage the owner in a physical confrontation to try and take possession of the car. If they were to beat the owner up to repossess the car, they committed a crime because that was within the course and scope of their employment. Their employer would be liable. Now, a real big point that I'm sure all of you have noticed is a corporation can't be imprisoned. That's true, but they can be fined or denied certain legal privileges, like being allowed to participate in certain business ventures. Now, corporate directors and officers are personally liable for the crimes that they commit, and they may be liable for the actions of their employees. right? If those employees are under their supervision and they directed them to commit the illegal act. Now, this all falls under the responsible corporate director doctrine. The responsible corporate director doctrine, right? And if you just look at what it means, is you're responsible for yourself and for those you give orders to. You're responsible for yourself and those you give orders to. Let's take a moment to talk about some of the crimes that might affect businesses. First on our list is forgery. Forgery is the fraudulent making or alteration of any writing that changes the legal liability of another. Right. An example of forgery that should be really obvious is if you sign your name, or excuse me, if you sign somebody else's name, right, to a contract, right? A contract binds a party to do something, right? It changes their legal liability, right? If you put their name on the contract without their knowledge, that's forgery. Robbery, the taking of another person's personal property from his or her person or immediate presence by force or intimidation, right? I'd like you to pay particular attention. In order for it to be a robbery, you have to take it from a person's presence or person, meaning they have to be there. Also, by force or intimidation. What would force be? You hit somebody in the back of the head with a stick to steal their wallet. That's force. What would intimidation be? You threaten somebody. If you don't give me your money, I'm going to blow your brains out. That would be intimidation. Burglary is the breaking and entering the dwelling of another at night to commit a felony therein. The breaking and entering the dwelling of another at night to commit a felony therein. Now, this is the common law definition of burglary, not the modern rule. Couple of key components. Burglary actually is multiple crimes, right? The thing that changes breaking, entering, and criminal trespass into burglary under the common law is that it occurs at night. It occurs at night. And point to remember also when you're thinking about burglary is that the purpose of the breaking and entering is to commit the felony therein. So you're breaking into somebody's house at night to commit another crime in addition to the breaking and entering. A key component of burglary is when the intent to commit the felony was formed. When the intent to commit the felony was formed. The intent must be formed prior to the breaking and entering. I'm going to say this again. The intent to commit the felony therein must be formed prior to the breaking and entering. Let's say you went to a party and it was a really, really good party. Let's say the party took place in February, the weather's kind of cold. Time for you to leave now, it's 3 o'clock in the morning. Now, your friend had a beautiful carpet on the floor, so normally when people have carpets, what do? You take your shoes off. You've had a couple of drinks, you get your coat, you leave the house, and you walk to the train. Now, you're about 6 blocks away from your friend's house before you realize you're not wearing your shoes. Your feet are really, really cold. You turn around to go back to your friend's house to get your shoes, and you notice this warm glow coming out of an apartment window. So you walk up the steps, and you look in there, and you see this beautiful fireplace. You open up the window because you're drunk, you don't have good sense, and you decide it's a good idea to go inside and warm your feet up before you go back to your friend's house. Here's the thing. You've been drinking, you've been walking. You sit on the couch, what do? You fall asleep. You wake up about 15 minutes later because you've been drinking, you have to go to the bathroom. So you look around for the bathroom, you notice the bathroom is in the bedroom. You go into the bedroom, you do your bathroom business, and when you come out, you see this beautiful Rolex sitting on the dresser. You take the Rolex, you put it in your pocket, you go back to the front to where the window you came in was, and you go out the window. As you're climbing out the window, guess who's there? New York's finest. NYPD is right there. They see you coming out of this house and they arrest you. Can they charge you with burglary? You might think so, but the answer is no. Why? Did you have a break-in and entering? Yes. But when you broke into the house, did you intend to steal anything? The answer is no. The intent to commit the felony, the intent to steal that Rolex, was formed after the break and entering and not the purpose of the break and entering. So the police could not charge you with burglary. They could charge you with breaking and entering and criminal trespass and larceny. That takes us to our next crime, larceny. Larceny is the wrongful or fraudulent taking and carrying away by any person the personal property of another. Now, the thing that distinguishes larceny from robbery is first, that the other person, the person whose property is being taken, is not required to be present. Second, there is no use of force or intimidation. Now, a variation on larceny is larceny by trick. Larceny by trick is representing as true some fact or circumstance that is not true with the intent of deceiving and with the result of defrauding an individual into relinquishing possession of property without adequate compensation. Essentially, larceny by trick is a grift, it's a con. Someone cons you into giving your property to them. Now, slightly different, but falling along the same lines, is obtaining goods by false pretenses. This is representing as true some fact or circumstance that is not true with the intent of deceiving and with the result of defrauding an individual into relinquishing title to property without adequate consideration. Here's the thing. What makes it a different crime is what the perpetrator gets. They get title to property, not possession of property. Now, of the two, obtaining goods by false pretenses is much more serious. Why? Title represents ownership, possession does not. Think about this. If you rent an apartment, do you have possession of that apartment? The answer is yes, you do. Can you sell the apartment? The answer is no. However, if you own the building in which your apartment is located, can you sell the apartment? Can you sell the building? The answer is yes. Why? Because you have title to the property, right? So obtaining goods by false pretenses is a more serious crime because title is more valuable than possession. Receiving stolen goods is a crime if the person who received the goods knew or should have known the goods were stolen. Now, the new part is very straightforward, but the should have known might be a little tricky. And here's how you rectify that. If you receive goods in a place where you would normally get those types of goods, it's unlikely that you would be charged with receiving stolen property. For example, if you go to a pawn shop and you buy a used watch in a pawn shop and it turns out that the watch is stolen, you would not be liable for receiving stolen goods. Why? There is no mens rea. There is no intent to commit a crime because where would you get a used watch? A pawn shop. By the same token, if you're sitting in a barber shop or a beauty parlor and someone walks in off the street and says, I got Gucci Rolexes for sale, Gucci Rolexes for sale, I give you a good price, and you decide to buy one of those, here's the thing. Is that the type of place that you would normally purchase a watch, especially a luxury watch? The answer is no. So even if you did not actually, in fact, know the watch was stolen, you should have known. Last on this slide is arson. Arson is the willful and malicious burning of a building or some other structure, and in some states, personal property. That's setting fire to something, right? Now, key is it has to be somebody else's property. If it's your property, you're allowed to destroy it. If it's someone else's property, you're not allowed to burn it up. Some of the crimes that you will have to watch out for while running your own business or being an executive with a business are white collar crimes. White collar crime is often committed during the course of a legitimate occupation and can be difficult to detect. Embezzlement is the fraudulent conversion of property and money owned by one person but entrusted to another. The key here is that while the property is owned by one person, another person has control over that property. An example would be a corporate CFO. That person is responsible for writing all of the checks of a corporation to pay that corporation's bills. Let's say the CFO is a little short on money. Maybe his daughter's tuition is coming due. So he writes a check from the company's account to cover his daughter's tuition. That would be embezzlement. He was empowered to write checks for the corporation, but it was limited to doing things that were good for the corporation. When he wrote the check for himself, he took property that was not his, the corporation's money, and used it for himself, which is not the purpose that it was entrusted to him for. Now, it does not matter that he intends to return the money. All that matters in this case is that he intended to use the money for himself. That's the mens rea, right? The writing of the check in this case would be the actus reus, the guilty act. Next, we have fraud. Fraud is an intentional deception made for personal gain or to damage another individual. At common law, fraud has four elements. One, representing as true a material fact or condition with knowledge that it is false or reckless disregard for the truth. That means you know you're lying or you don't care that you're lying. Second is an intent to deceive. The reason why you're telling a lie is because you want someone to believe you. Third is justifiable reliance by the plaintiff. This simply means that there is some reasonable basis for the plaintiff, the injured party, to believe the lie. And four, damages suffered by the plaintiff as a consequence of the reliance. That means that because the plaintiff believed you, he or she, in fact, suffered some harm. Now, most jurisdictions in the United States require each element to be pled with particularity and proven with clear, cogent, and convincing evidence, right, to establish a claim for fraud. That means that these things are not subject to interpretation, right? All four elements must be clearly and cleanly established to make someone liable. This slide lists the various types of fraud. I leave it to you to read the definitions. Just bear in mind that the same requirements are necessary for all types of fraud. All four elements must be proven. A computer crime is any act that is directed against computers and computer parts, that uses computers as instruments of crime, or that involve computers and constitute abuse. These include financial crimes, property theft, vandalism, destructive programming, and software piracy. Bribery of public officials occurs when a bribe is tendered. The official does not have to accept or do anything to accept the bribe. Making the bribe is the crime. Now, a bribe can be anything that the official considers to be valuable. An example of bribery of a public official would be if you get pulled over for a parking ticket and you offer the cop $100. The cop does not have to accept $100 for you to be guilty of bribery. Extortion, also known as blackmail, is the making of threats for the purpose of obtaining money or property. Insider trading occurs when an individual who obtains material inside information about a corporation uses it to make considerable profit from the information to buy or sell the corporate's securities. Insider trading is covered under federal securities law. The theft of trade secrets. The Economic Espionage Act of 1996 made the theft of trade secrets a federal crime. The act also made it a federal crime to buy or possess trade secrets of other persons. Knowing that the trade secrets were stolen or otherwise acquiring them without the owner's authorization. An individual who violates the act can be imprisoned for up to 10 years or fined up to $500,000. A corporation or other entity can be fined up to $5 million. Any property acquired as a result of the violation and any property used in the commission of the violation is subject to forfeiture, meaning that the government can seize it. RICO criminal violations. Passed in 1970, the Racketeer, Influenced, and Corrupt Organizations Act, RICO, is a federal law designed to combat organized crime in the United States. It allows prosecution and civil penalties for racketeering activities performed as part of an ongoing criminal enterprise. Traditionally, obtaining or extorting money illegally or carrying on illegal business activities usually of organized crime. A pattern of illegal activity carried out as part of an enterprise that is outlawed or controlled by those who engage in the activity. RICO has become an effective tool for attacking securities fraud involving the sales of stocks and bonds, and mail fraud, which were criminal violations of RICO. With crimes covered, the types of crimes, the requirements for establishing criminal liability, it's time for us to move to defenses to criminal liability. Now, one point that I want to make crystal clear is that all defenses are affirmative defenses. An affirmative defense is either a justification or an excuse for the defendant having committed the accused crime. It differs from other defenses because the defendant admits that he did in fact break the law. He is simply arguing that either he has a good reason or an excuse for having done so, and therefore should be excused from all criminal liability. Very important point here. The burden of proof from an affirmative defense is on the accused. The burden of proof is on the defendant. Now, this is important because traditionally, the prosecution has to prove that the defendant committed a crime. When an affirmative defense is asserted, it flips. The defendant has to prove that they were justified in committing the crime, and the prosecutor simply has to poke holes in the defendant's defense. First among our defenses is infancy. Infancy is a defense based on the age of the defender. At common law, children up to the age of 7 were considered incapable of committing a crime because they lacked the moral sense to understand that what they were doing was wrong. There is an irrebuttable presumption that an infant up to the age of 7 could not form the mens rea necessary to commit a crime. This simply means that the law says they can't form mens rea, and you cannot make the argument that they could. Children between the ages of 7 and 14 were presumed of being incapable of committing a crime, but the presumption could be rebutted by showing that the child understood the wrongful nature of the act. This means that between 7 and 14, there was a rebuttable presumption that the infant could not form the mens rea necessary to commit a crime. In other words, the law says that they couldn't, but you could argue that they could. From 14 years to 17 years, there is a rebuttable presumption that the minor could form the mens rea necessary to commit a crime. This means that the law says that they are liable because they understand what they're doing is wrong, but you can now make the argument that they did not. If you look, infancy is based on understanding, which comes from experience. The older a minor becomes, and just to be clear, the terms minor and infant are totally interchangeable, the more that that minor or infant is expected to understand. Next is intoxication. Intoxication is a state in which a person's normal capacity to act or reason is inhibited by alcohol or some other drug. Now, the law recognizes two types of intoxication. The first is involuntary intoxication. Involuntary intoxication is a defense if its effect was to make a person either incapable of understanding that the act committed was wrong or incapable of obeying the law. Now, when we say involuntary, what does that mean? That means that they did not get intoxicated on purpose. You frequently see this when someone's on prescription medication, maybe 2 pills, and they interact with one another in a way that they had not anticipated. They did not know the effect was going to occur. So if they commit a crime while under the influence of these drugs, not knowing how it would affect them, right, that's involuntary intoxication. The second type of intoxication that the law recognizes is voluntary intoxication. Voluntary intoxication is a defense if it precludes having the required mental state, but is not a defense for the crimes of recklessness or negligence. Just to be clear, driving under the influence is a negligence crime, right? You are responsible for everything that happens after your decision to become intoxicated. Now, the distinction is very, very important, right? If you look, both involuntary and voluntary intoxication preclude having the required mental state. However, if you get drunk or high on purpose, you are still responsible for certain types of crimes, whether you knew what you were doing or not. Insanity, a popular type of defense, is used to defend against charges on the ground of insanity. Now, in order to use it, the defendant must meet the test for legal sanity. Now, most state courts and the majority of federal courts use a standard found in the Model Penal Code. A person is not responsible for criminal conduct if, as a result of mental disease or defect, he lacks substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. States that don't use the Model Penal Code use the McNaughton test, right? Now, the McNaughton test is basically the same as the irresistible impulse test. You know something's wrong, but you can't help yourself. Now, a common example of insanity would be kleptomania. Right? This is a condition where a person cannot control their urge to steal. They know what they're doing is wrong, but they cannot stop themselves. Now, of the defenses, and we're going to talk about a few more, insanity is possibly the worst. First, it's very, very difficult to prove insanity. Two things have to happen since the burden of proof is on the defendant. The defendant has to come with his or her psychiatrist, and they have to prove that they are legally insane. Now, of course, the prosecution is going to rebut this, right? And they're going to bring their psychiatrist out to prove that the person is sane. Now, here's the thing. It's very, very easy to pretend to be insane for a short period of time, but it's very difficult to keep it going. So, hard to beat the prosecutors and psychiatrists. Second part, pleading insanity does not give you a free pass. If someone is acquitted on the grounds of being insane, they don't send them home. You know where they send them? To an insane asylum. Now, here's the bad part. How long do you confine someone to an insane asylum? The answer, until they're no longer a danger to themselves or to others. Now, here's the bad part. How long is that? No one knows. Now, if you get sentenced to 5 years, how long do you serve? 5 years. But if you get out on the grounds of insanity, you're acquitted on the grounds of insanity. And let's say that you've done something that is very interesting. You're a doctor, the treating psychiatrist is writing papers, doing presentations based on how crazy you are. When do you get out? Possibly never. Second, in light of John Hinckley attempting to assassinate President Reagan and being acquitted on grounds of insanity, many folks are very upset. So politically, in some jurisdictions, the laws have changed. Right? They can find you now insane but guilty. When there's a finding of insane but guilty, frequently they'll confine the defendant to a mental facility until they're sane enough to understand what they did, and then they'll put them in prison for the balance of the sentence, or not really even the balance, to start beginning the sentence. So let's say you commit a crime, they find you insane but guilty, they sentence you to 25 years, they put you in a mental institution, and it takes them 15 years to make you sane, or sane enough to understand what you did was wrong. When they let you out of the mental institution, you start serving your 25 years. So instead of being locked up for 25 years, how long are you locked up? 40 years. Insanity is not ideal. Our next offense is mistake. A long-standing rule in criminal law is that a mistake of fact is a valid defense, whereas a mistake of law is not. The general rule is a person accused of a crime cannot dodge responsibility by claiming he did not know the act was illegal. In some states, however, a person who claims that he or she honestly did not know that a law was being broken may have a defense if, first, the law was not published or reasonably made known to the public, the law was not published or reasonably made known to the public, or if the person relied on an official statement of the law that was erroneous. Now, let's examine the first exception. A law was not published or reasonably made known to the public. This means that the government changes some laws, and they do it kind of on the fly. They don't tell people that laws are changing. They don't publish the law, right? If someone were to break a law in that case, they could say they did not know what they were doing was illegal. An example of this would have been when New York City started their recycling laws, and then they required some garbage to go in clear bags and some garbage to go in blue bags, and then they reversed the type of garbage that went in each bag. Now, what did the city do? They did a referendum on the enforcement of the law for about 30 days, and they ran ads on TV and newspapers and put billboards up to specify what garbage went in what bag, right? They had to make sure that the law was published so people could not say they did not know what they were doing was wrong. Now, the second situation, if a person relied on an official statement of the law that was erroneous, right? If you've ever driven in Manhattan, particularly Midtown Manhattan, you might notice that when you find a parking space, a lot of times there'll be a pole there, and the pole will have different signs with different information. Some say you can park, some say you can't park, some say only certain types of cars can park. So you're very confused. In a case like that, what do? You ask a police officer. So the police officer looks at the sign, looks at your car, says, no problem, you can park here. You go about your business, you come back, guess what? You got a ticket on your car. What's your defense? Your defense is you relied on an official statement of the law that was erroneous, that was wrong, right? You relied on what the police officer told you, someone who's supposed to know the law, and that police officer was wrong. That would be a valid defense. Now, a mistake of law is very different than a mistake of fact. A mistake of fact will operate as a defense if it negates the required mental state. Let's say you decide that you want to kill your worst enemy and you plan to kill this person, but before you get your chance, they're hit by a car, they end up in the hospital. You say this is perfect, they went in, they're never going to get out, so you plan to go to the hospital and kill them. You sneak into the hospital, 3 o'clock in the morning. You get to their room, there's nobody there. So you take a pillow off the bed next to them and you hold it down on their head for 15 minutes. You know they're dead now, and you leave. Now, what you did not notice is that their monitor had flatlined before you got there. When you got there, they were already dead. Basically, you just suffocated a dead person. But in any event, the nurse sees you leaving the room, goes in the room, sees the patient is dead, calls the police arrest you and charge you with murder. Well, here's the thing. You made a mistake of fact. The fact you were mistaken about was the condition of your victim. And here's the thing, hard to believe, but you really can't kill a dead person, right? The fact that he was already dead negated the required mental state. Now, once again, in case you forgot, murder in the first degree requires the intentional killing of a living human being with a forethought and malice. The fact that he was not living meant you couldn't have killed him. Defense, defense, defense. Another popular defense is consent. Consent is permission. Consent is a defense if it cancels the harm that the law was designed to prevent. So the question is whether the law forbids the act against the victim's will or forbids the act without regard to the victim's wish. For instance, the law forbids murder whether or not the victim consents. Consent is most successful as a defense to charges involving crimes against property. You're married and your cousin's over at your house. Your cousin has an emergency, needs to get to the hospital because his wife's about to have a baby. So you let your husband use your husband's car. Your husband comes home, his car is gone. What does he do? He calls the police. The police find the car with your cousin in it. They arrest your cousin and they charge him with grand larceny. Your cousin's defense is consent. You gave your cousin permission to use your husband's car. Now, as I'm sure you remember, when you get married, you become a single entity. So your husband's car is your car. Thus, your cousin had permission to use the car. No crime was committed. Our next crime is, our next offense to criminal liability is duress. Duress exists when a wrongful threat induces a person to do something he or she would not otherwise do. Duress negates the necessary mental state if 1, the threat is of serious bodily harm or death, 2, the harm threatened is greater than the harm that will be caused by the crime, 3, the threat is immediate and inescapable, and 4, the situation arose through no fault of the accused. Now, please bear in mind, all 4 requirements must be met to use the defense of duress. The harm threatened is greater than the harm that will be caused by the crime. So here we go. I tell you, if you don't kill Dave, I'm going to kill you. So you kill Dave. When you're charged with murder, you claim duress because I threatened you with death. Well, duress would not work here. Why? The harm threatened is equal to the harm that you caused. Now, if I said, if you don't rob this bank, I'm going to kill you. Well, the harm threatened is greater than the harm that would be caused by robbing a bank. Second, the threat must be immediate and inescapable. Right? Now, if I tell you, if you don't rob the bank today, I'm going to kill you next Thursday, the rest could not be a defense. Why? Between now and next Thursday, can you get away from me? The answer is yes, it's escapable. If it's next Thursday, is it immediate? No. Now, finally, the situation arose through no fault of the accused. That means that if you and I got into a situation where we agreed together to rob a bank, and then at the last minute, you changed your mind and I said, if you don't do this, I'm going to kill you. Guess what? The situation arose because of you. So duress would not be a defense in this case either. Once again, all four elements must be met in order to use duress as a defense. One of the most popular defenses is justifiable use of force. Generally, people can use the amount of force that is reasonably necessary to protect themselves, their dwellings, other property, or to prevent the commission of a crime. Now, a couple of things are really important when we talk about justifiable use of force. And the first one is deadly force. Deadly force can only be used in self-defense if there's a reasonable belief that imminent death or great bodily harm will occur. If it's not, if the attacker is using unlawful force, and if the person has not initiated or provoked the attack. Deadly force normally can be used to defend a dwelling only if the person reasonably believes that it's necessary to prevent imminent death or great bodily harm, or in some jurisdictions, if the person believes deadly force is necessary to prevent the commission of a felony, a serious crime, in the dwelling. In the defense of property, the use of non-deadly force is justified to prevent or to end a criminal attempt to take away or otherwise interfere with the property. Deadly force normally can be used to prevent only crimes that involve a substantial risk of death or great bodily harm. Now, this last point is really the key to everything. Deadly force normally can only be used to prevent crimes that involve a substantial risk of death or great bodily harm. So, where does this leave us? Justifiable use of force really just means reasonable force, right? What is reasonable force? It's the amount of force that is necessary to protect yourself. Now, reasonable is not equal. If I have a knife and you have a gun, you don't have to go get a knife to knife fight me. You can shoot me. Why? If I'm using a knife against you, that's deadly force, right? Conversely, if I slap you, you can't shoot me because that would be considered to be excessive. All right, that would be considered to be excessive, right? So justified use of force is really reasonable force. And just to highlight New York State, in New York, you have a duty to retreat if it's safe to do so. In New York State, once again, you have a duty to retreat. So if you can run away safely in New York State, you must. Entrapment occurs when a government officer suggests that a crime be committed and pressures or induces an individual to commit it. The defense is not intended to prevent police from setting a trap for unwary criminals. It is designed to prevent the government from encouraging persons to commit crimes. The important issue is whether a person who committed the crime was predisposed to do so. Now, just to be clear, if someone was predisposed to commit a crime, the police are in fact allowed to set traps. Right? Classic example of this would be the prostitution sting, where they have an undercover police officer dressed up as a prostitute. When a potential client pulls up in a car and says, "I got $25, what can you do for me?" The officer pulls out a badge and arrests the potential client. That's a trap. That's not entrapment. Entrapment only occurs if first it was the police officer who put the idea to commit the crime in the accused's mind and then pressured the accused to in fact commit the crime. It wasn't their idea. They really didn't want to do it, but the government officer pushed and pushed and pushed to make it happen. Next, we have statutes of limitations. Now, these are laws that were passed by legislative bodies in the common law system to set a maximum time after which an illegal event occurred where a person could be prosecuted. Now, some things that should be obvious: felonies being serious crimes usually have longer time limits than misdemeanors. And on the most serious crime of all, murder, there is no limitation at all. Now, the limit is suspended if the suspect leaves the state or cannot be found. Meaning, if you were to commit a crime in New York State and then you go to California, the limit tolls, the limit stops until you come back in New York State, and then it runs again. So if a crime had a 4-year time limit and you left New York State for 6 years, then you came back to New York State, the day you came back, the 4 years would start running, not from when you committed the crime. Now, time may be subtracted if the suspect is not available to stand trial. Right? Same thing applies. Same thing applies. Immunity from prosecution is a doctrine of law that allows an accused to avoid prosecution for criminal offenses. Immunity is generally used by the prosecution to obtain information. Once immunity is given, a person may be compelled to answer questions, which cannot otherwise be done because of the Fifth Amendment. Right now, the Fifth Amendment protects against self-incrimination. Now, often, the grant of immunity from prosecution for serious crimes is part of a plea bargain under which the defendant may still be convicted for a lesser offense. And the states use his or her testimony to prosecute accomplices for committing serious crimes that carry heavy penalties. One of my favorites occurred in North Carolina probably about 20 years ago, where there was a home invasion. 3 people did it, 1 young lady, 2 men. And the young lady involved copped a deal, right? She copped a deal for testifying against her co-conspirators. She got a lesser sentence. And I was very, very amused because, they killed a family of 5. Not that that was amusing, but her co-defendants, her co-conspirators, received sentences of 160 and 165 years respectively. Now, they did give her a lesser sentence. She got 125 years. So that means she still went to jail. I was very pleased about that. Constitutional safeguards and criminal procedure. Generally, they are referred to as crim pro or criminal procedure. They include the 4th, 5th, 6th, and 8th Amendment protections. These safeguards apply to all federal courts. The United States Supreme Court has ruled that most of them also apply in state courts by virtue of the Due Process Clause found in the 14th Amendment. These safeguards include the 4th Amendment protection from unreasonable search and seizures, the 4th Amendment requirement that no warrant for search or arrest can be issued without probable cause, the 5th Amendment requirement that no person can be deprived of life, liberty, or property without due process of the law, the 5th Amendment requirement that no one can be compelled to testify or provide evidence against oneself, the 5th Amendment prohibition against double jeopardy, the 6th Amendment guarantees of a speedy trial, trial by jury, a public trial, the right to confront witnesses, and the right to legal counsel, and the Eighth Amendment prohibition against excessive bail and fines and cruel and unusual punishment.